Good evening, attendees. We will be beginning our webinar in just a couple of minutes. Please stand by. Good evening, attendees. We'll be beginning our webinar in just a couple of minutes. Please stand by. We'll be beginning our webinar in just a minute. Please stand by. Good evening and welcome to our webinar, Small Business Legal Issues. It's being brought to you by the Buffalo Niagara chapter of SCORE and by our presenter, John Donner. I'm SCORE Workshops Coordinator Ted Galantowitz, and I'm pleased to have you here and serve as your host. Before I hand over the controls to our presenter, just a couple of announcements. This session is being recorded, and the recording link will be emailed to all attendees by tomorrow. You'll also be receiving a PDF copy of tonight's presentation slides. All attendees' microphones will be muted during the presentation. If you have a question or a comment, please use the Zoom chat feature. We will allow microphones to be opened up at the end of the presentation for those of you that still have questions at the end of the presentation. I will be monitoring the chat during the presentation. During the presentation, please use the chat for questions and comments. Within the next 48 hours, all attendees will be receiving an evaluation form regarding this evening's presentation. Please complete the form and return it via email. I'd like to let you know that this webinar is part of SCORE's commitment to promote the success of small business. We do this through local and nationally available training events, one-on-one mentoring, and by providing numerous online informational resources. SCORE is the volunteer arm of the Small Business Administration with hundreds of chapters and thousands of unpaid volunteers throughout the United States. Our Buffalo chapter has about 50 members. Our mentoring is free and confidential, and most of our educational events are free. You can contact us at buffaloniagara.score.org, and also please visit our national website, score.org. We also are very much interested in having new volunteers to our Buffalo Niagara chapter. You can also indicate your interest in volunteering for SCORE by going to our SCORE website. Please note that our Buffalo Niagara chapter has scheduled the following webinar workshops from now into January. Tomorrow, Tuesday, December 13th at 10 a.m., our Google partners will be presenting Reach Customers Online with Google. It is being presented by a Google trainer. On January 14th at from 9 o'clock in the morning until 5 in the afternoon, we have our 8-hour in-person workshop called Starting and Managing Your Own Business. It's presented by experienced business experts, and the various sessions cover the basics of starting and managing your own business. It's going to be held at the downtown Buffalo and Erie County Central Public Library. That again is the 14th of January from 9 o'clock till 5 o'clock at the Buffalo and Erie County Central Public Library. We also in January, on Wednesday, January the 18th, our Microsoft partners will be presenting Learn About Microsoft Teams. That's a 9 o'clock start on Wednesday, January 18th. You can register for all of our instructional webinars at buffaloniagara.score.org. And now let me introduce our presenter. John Donner is an attorney with the law firm of Roach, Lennon Brown here in Buffalo, New York. John is also a former managing attorney for the Western New York Small Business Legal Clinic and a past volunteer for SCORE Buffalo Niagara, as well as a regular workshop presenter for SCORE. John earned his law degree at the University of Buffalo and has degrees in engineering and business. John, I want to thank you right off the bat for taking time out of your busy schedule to speak with us tonight. We're looking forward to your presentation. The microphone and the controls are yours.
Okay, thank you very much, Ted. Good evening, everyone. Appreciate you taking the time. I know we're getting close to the holiday, so everybody's time's being compressed, so we're going to try and cover a lot of topics here. So the first thing I have to do is give the lawyer weasel language that, you know, this isn't legal advice because we're talking about generalities here, that we'd have to sit down and we'd have to look at your specific situation. So what are we going to talk about tonight? We're going to talk about a lot of the areas that small businesses come in contact with potential legal issues. So the first thing we're going to talk about is limited liability. And specifically, we'll talk about how organizational structure can affect the liability that the owner of the business is personally subject to. We'll talk a little bit about contracts and leases. We'll talk about employees versus independent contractors, a little bit about licenses and permits, And we'll talk a little bit about intellectual property. Now, for a lot of small businesses, they may not have patents, they may not be worrying about trademarks, service marks, but they may have confidential information that they want to have certain protections in place. So that's where it'll come into play for a lot of small businesses. So we'll start right out with understanding limited liability. So John decides that, hey, this law thing isn't working out. So I'm going to start a small business and I'm going to provide janitorial services for commercial clients. So I go out, I buy the equipment, the supplies, get the training I need, get contracts from several businesses. I'm fully compliant with the industry standards and I follow the industry practices and the duties of care. So one day, I have an account with the local bank and I've washed the foyer floor, put up those nice yellow plastic signs. Somebody walks across the foyer, slips on the recently washed floor, they fell, they're seriously injured. Now, a year later, the injured party is suing for their medical expenses, their pain, their suffering, their lost wages. So how can organizational structure affect my personal liability? So we'll take a look at situation number one. I'm a sole proprietor. I went down to the county clerk's office and I filed a DBA for John's Commercial Cleaning. So this is an informal business structure. So as a result, the business isn't filed or created under state law. So I am the business. So in this case, all my personal assets can come into play as well. So not only the assets of the business being equipment, bank accounts, other assets, but my personal assets, my house, my vehicle, personal belongings, bank, retirement accounts, that could all come into play. All right, so now let's take an alternative situation. So I filed as John's Commercial Cleaning LLC with the New York State Department of State. So now I have this formal business structure that separates John, the person, from John's business. So I've created this corporate veil of protection. So now this same legal action is going to be against the business. So the liability is limited to the assets of the business. Now, if I'm not adequately insured and that shortfall, they go after the business assets, they're not going to go after my personal assets. So like I said, my house, my bank accounts, my cars, that kind of stuff. It's not going to be subject to any kind of taking under a judgment under most circumstances. Obviously, there are some rare occurrences. If there's some egregious behavior, gross negligence, willful misconduct, things like that. But for the majority of the time, in almost all cases, your personal assets are protected. Now, I'm still going to be liable for a couple of business commitments. So typically, with a small business, no matter how long you've been in business, if you get a loan from the bank, they're going to insist on a personal guarantee. So basically, you're co-signing for your business. So if the business fails, you're still going to be on the hook for that. And a lot of times in a commercial lease, you're going to have a personal guarantee on that as well. So you could be on the hook for rent, even if you're no longer utilizing the space until a replacement tenant comes in. And then finally, if there's various tax obligations, so the government will go after you on that. But in terms of the slip and falls, the lawsuits, that kind of thing, your assets are going to be protected. So we look at the basic organizational structures and the level of personal liability. So we talked about the sole proprietorship. You go down, you file a DBA with the county clerk's office. And like we saw in our first example, there's an unlimited personal liability for the owner. Partnerships, for the most part, are worse because you've got something called joint and several liability. So what happens here is that you're going to have unlimited personal liability for your actions. And if you're the person with the deep pockets, you could have unlimited personal liability for the actions of your partners as well. So, it can be a lot of concerns there. Under the LLC, limited liability for the members and the owners. And member is a generic term for an owner in an LLC. Corporations, same thing, limited liability for shareholders or owners. And again, those are two terms for owners, the counterpart of a member in an LLC. Now, in some cases, if you're a professional, you can't have an LLC because obviously we want professionals to be held accountable for the services they provide. So professions like doctors, lawyers, professional engineers, architects, that kind of thing, they can't file an LLC or a corporation. So what they can do is create a professional services limited liability company or a professional corporation. And what that will do is that'll give them partial limited liability protections. So in that case, you're going to be indemnified for the non-professional issues that come. So that would take care of like the slip and falls and things like that. The other aspect doesn't help you if you're a single member PLLC or PC, but if there are multiple partners involved, it takes care of that joint and several liability component in terms of malpractice, in that you're only responsible for your own actions and you're not responsible, you're insulated from the malpractice of your partners. So it becomes a lot more valuable when there's multiple people involved in the organization. All right, tax treatment. So if you're a sole proprietor, you're considered a disregarded entity. So it just flows right through into your personal income tax. Typically, it's going to be Schedule C, E, or F, and it depends on what kind of business you have. One of those is like for agriculture, about 90% of the time it falls under Schedule C. If you file as with more than one member with the county, you're going to file as a partnership, and then you're going to be classified as a partnership come income tax time. So it's going to be based on the percentage ownership that you have in the partnership. And if it isn't spelled out in a partnership agreement, the state and the federal government are going to assume that everybody's equal partners. With corporations, the standard, the default is the corporate C tax status, where you're taxed at the entity level. People talk about the double taxation of corporations. So what they're talking about is there's a tax return for the entity and they're paying income tax on the profits. And then once the profits are distributed to the shareholders, the owners of the business, then that's taxed as income to the shareholders and the owners. So that's, we talk about that double taxation. So, one of the tax elections for corporation is they call a subchapter S. It's not a type of corporation. It's a tax election for a corporation. All corporations are C by default, and then this is just a tax election. And so what that does is that eliminates this double taxation, and that all the earnings flow through to the shareholders of the organization. All right, and there are some limitations on that. So, I mean, only 100 shareholders, they have to be US citizens. There's a number of restrictions. And if you don't meet those restrictions, then by default, you go back to the Chapter C status. Now, with an LLC, there's a lot of options. So the default, if it's a single member entity, it's the disregarded entity. So it's treated just like the sole proprietorship. It flows through. Same thing, a multi-member, the default is a partnership. Again, it flows through. Now, there could be some instances, maybe there's a lot of capital involved, there's a lot of members, that it may be an advantage to either have corporate tax status as a C Corp, or you have the subchapter S. So what the beauty of this is that, let's say you don't meet the requirements of S and you don't want the double taxation of a C Corp, you still have those defaults as a disregarded entity or a partnership. So there's options, and you can't necessarily switch every year, but if the conditions dictate it and circumstances change, I think it's every 5 years you can change your designation. All right, so I just want to do a quick comparison because most small businesses aren't good about their documentation. I have a client right now that they never did an operating agreement. They don't have an employment agreement. Nothing's in writing. They've been in business for 12 years. Now the two partners are suing each other because they're saying, you haven't kept up your part of the bargain, although the bargain's not in writing. So when we look at a comparison, you see that for a limited liability company, we have, think of it as the birth certificate for your business, a document called the Articles of Organization. The counterpart for a corporation is the Certificate of Incorporation. Then in each instance, you're going to go and get an employer identification number or an EIN, and that is pulled in from the IRS. Then the rest, for a closely held business, the rest of these are going to be internal documents. If you're publicly traded, when you look at like the bylaws, the stock, that stuff is going to be a matter of public record. But for a limited liability company, you have an operating agreement, which kind of defines the duties and responsibilities of each of the members. It'll talk about the capital contributions. It kind of outlines the operational aspects of the business. The counterpart to that in the corporation would be bylaws. Then, of course, with an LLC, there is no stock. You can have membership units. That's a rather new kind of counterpart to that, but for the most part, that's not necessary. With a corporation, the default is you're going to have 200 shares of stock authorized. You can make it however many shares of stock you want at the point of time when you're filing the certificate of incorporation. So then you're going to have a stock agreement, which is going to talk about the issue of stock, buybacks, that kind of thing. You're going to do your initial issue of stocks, the certificates, the amount of shares per certificate, that kind of thing. And then stock ledger is basically going to be a spreadsheet that shows the initial issue of the stock. And if there's any transfer during the life of the corporation, it shows the parties that it's transferring from and to. Then you're going to have an organizational meeting with a corporation. So that's going to be where you establish the initial slate of officers, the initial directors, you adopt the bylaws, the certificate of incorporation, the stock agreement, those kind of things. Not needed, but I recommend when I form an LLC, now I do organizational meeting minutes as well for the LLC, just so they have documented, who's going to do what and the various contributions, that kind of thing. Then you look at,
John,
yes.
We do have a question in the chat. Is an operating agreement required for a single member LLC?
They say it is, but nobody enforces it. And it really, it doesn't mean an awful lot because you're holding all the offices. You put 100% of the capital in there. The reason I would do it is that down the road, you may bring in another member. It could even be a family member. You may want to issue a minority stake in the organization, that kind of thing. But the reason you may want that is if you have, and it's not filed with anybody, but if you're going for a bank loan, small business certification, things like that, that's a document that's going to be on the checklist that you have to submit. So that's why whenever I form an LLC, I create an operating agreement for the client. Then we talk about other, what I call recommended recordings. So I say for an LLC, I would want to do just, it could be 1-page minutes of the organizational meeting that you've had with yourself, that you've appointed yourself to all the offices, that kind of thing, and that you've adopted the operating agreement, that the articles of organization, that kind of thing. And then, sometimes there's going to be a change to the operating agreement. You add a capital investment, you add a partner, you take a partner out, that kind of thing. It's going to change. But there's also going to be other material changes. Maybe you decide to expand product lines, go after a small business certification, get a bank loan, those kind of things, where I think it makes sense to have kind of a memo to the file special meeting minutes that kind of memorializes that, because you forget over time the sequence of events that takes place. So this is a way that you document those changes. So you have that chronology of the evolution of your business. Now, you should be having annual meetings and board of directors meetings with a corporation. And again, it can be handled by memorandum, handle it that way. And then special meetings when there's maybe some issue that needs special attention that, you're not going to wait till the annual meeting, and it can be a dedicated meeting towards that issue. So it's important to kind of document that kind of stuff. And then what I call the operational documents. So contracts you have, agreements, supplier agreements, invoices, financial statements, tax returns, other documents that pertain to the day-to-day operations of your business. And those are going to be kind of consistent regardless of whether you're an LLC or a corporation. So you can see there's a little more documentation in place, requirements with a corporation over versus an LLC. And for the most part, most small businesses go with the limited liability company because there's a lot less of an administrative burden involved. All right, so when we talk about considerations in selecting a business entity, think about the anticipated growth. If you're going to open up a family corner store, okay, you're not going to be selling a lot on the World Wide Web. So, and you're not going to be franchising. You're not going to have a lot of investors, maybe family members or something like that. So that makes a good argument for a corner store, for a corner store to have an LLC. If you're going to do software development and you're looking at starting up a business and then getting some venture capital and then selling out, it may make sense to form a corporation rather than an LLC. Because one of the issues you can have with an LLC is all of a sudden, if there's a tremendous capital appreciation, without physically having the benefit of that capital appreciation, you can get taxed on it. So it's really an issue that when you're in the planning stages, you should probably talk to a small business accountant. For most small businesses, the LLC is a more practical solution. While I was at the law center, I formed somewhere in the range of 450 limited liability companies and probably 6 corporations in that same period of time. So, it gives you an idea of kind of what that balance is. Are you going to have a brick and mortar location? If you are, you probably want to stay away from either a sole proprietorship or a partnership because you've got that dangerous slip and falls, that kind of thing. Are you going to be selling products and services in multiple jurisdictions? If you're selling online, a lot of issues could come up, even things like trying to deal with Amazon and Etsy and things like, especially Amazon. A lot of times they won't deal necessarily with an individual. They want to deal with a corporate entity. So LLC or corporation. Products and services being offered. If you're selling a food product, it's going to be ingested. There are, people could have allergic reactions. The same thing, anything that's applied to a person, whether it's makeups, deodorants, that kind of thing, there could be an allergic reaction. Probably makes sense to have a formal business organization. Even if you have, let's say you're doing jewelry or toys or something like that, you always have that potential for choking hazards and things like that. Probably makes sense to formalize your organization. If you're going to have partners, you want to get away from that joint and several liabilities. So you want to have a formal organization. Are you going to have investors? Especially, it's one thing if you've got, a relative who's just going to give you some seed money and they're not really concerned about making any money on it or getting paid back right away. But if you're going for a venture capitalist or an outside investor, the fluidity in the investment, you probably want it to be, a corporation or an LLC as opposed to a sole proprietorship kind of thing. Consider the administrative burdens and costs. That's really kind of irrelevant these days because you can, if you do it yourself, you can form an LLC or a corporation for $500. And you see from a reporting standpoint, especially with an LLC, there's not an awful lot more than if you had a sole proprietorship, and probably the same or less than if you had a partnership, because you're still going to have an agreement there. The corporate veil of protection. Obviously we saw from my example with commercial cleaning, the benefits of having that corporate veil of protection. The taxes, we took a look at with the LLC, you have the options to go under like the corporate C or an S, as well as be a disregarded entity or a partnership, depending on how many individuals are involved in the business. The current future assets of the owners, because obviously, if you don't own anything, you don't have to worry about it. If you've got your mother or your grandmother lives in the senior center and she's selling, knit stocking camps at the Christmas bazaar, she probably doesn't need an LLC. But, if you're doing something, that has more restrictions, more potential for damages, then you want to look at a formal business organization. Finally, if you're going for a small business certification, probably makes sense to have a formalized organization. And now even sometimes clients are going to drive that you have a formal business organization as well. I've seen individuals that are consultants, like say a statistician, where their client insists that they form an LLC or a corporation, because if they're just paying, John Donner, the mathematician, then they have the chance that the Department of Labor could come in and say, John Donner's not an independent contractor. He's a part-time employee, or he's a temporary employee, or something like that. And so you have to take care of withholding, workers' comp, disability, all that kind of stuff. Whereas if it's John Donner LLC, all of a sudden it's a business-to-business contractual arrangement. So I'd kind of help support that argument that it's not an individual or a part-time employee. Okay, where should you register a business? Well, there's no such thing as a federal corporation or a federal limited liability company. It's going to be at the state level. And my advice to clients is always, hey, if you live in New York, you operate out in New York, you're paying income taxes in New York, just file as a domestic limited liability company. When they talk about domestic versus foreign, they talk about, did you form it in the state you reside in, or was it formed outside of, in our case, New York State? So you look at, where's the business going to be located? Where do owners live? You hear this thing about business-friendly states, that Delaware is a business-friendly state. Well, they are, and they have for business issues, they have a separate court and separate court process. So it kind of expedites things. But, New York State, LLCs are a very new business entity, relatively speaking. Partnerships and sole proprietorships have kind of go back to the history of mankind, and corporations have been around for hundreds of years. LLCs, the concept first came out about 45 years ago, the late 70s. And one of the earlier adopting states was Delaware. And New York State, the laws weren't on the books until 1995. So this is really a new organization. So that's why, you may have a relative or a friend that's a small business that maybe is a couple generations old, and they look at it and say, how come we formed a corporation? How come we didn't do an LLC? Well, because they didn't exist when you formed your organization, that kind of thing. But the problem with the friendly states, so for example, with Delaware, yeah, the friendly state, but they're going to charge you, I think it's $200 a year, a franchise fee. And if it's due the 1st of June, and if you pay it the 2nd of June, there's a $200 surcharge, and it just goes on and on and on. And then if you are doing the bulk of your business in New York, you're going to have to register as a foreign corporation or a foreign LLC, which has the same filing fees, same process, everything else. So there can be a lot of added cost and not necessarily any bonus associated with it. And then, of course, like I said, there's additional costs now. All of a sudden, you're supporting multiple jurisdictions. Now, just a little clarification here. If you're filed as an LLC in New York, that doesn't preclude you from selling outside of New York. You don't have to necessarily register as an LLC in Pennsylvania or California or things like that. It depends on what the presence is. So let's say, here we are in New York State, and I decide I'm going to manufacture paddle boards and surfboards. Well, there's not a big market for it here, but there could be a big market in California or in Florida. Well, if I'm just shipping all the stuff out, I can do that as a New York State LLC. But now all of a sudden, if I build a distribution warehouse or a manufacturing plant, have employees in these states, well, then I'm going to have to file as a foreign LLC or foreign corporation in those areas. But, a lot of it when you're starting out as a small business, it's not really an issue. Okay, so I guess, are there any other questions, Ted, on organizational structure?
No, there's nothing additional
Okay.
in the chat.
And then what we can do is at the end, if there are any questions, we can hit it at that time. So now we talk about contracts. So legally enforceable exchange of promises. So you'd have that theoretical widget. So we're going to deliver 50 widgets in exchange for $400. So, written contracts don't necessarily have to occur. You can have verbal contracts, but the problem with verbal contracts is you've got misunderstandings, you've got corporate amnesia, you forget, how do you strike up remedies, that kind of stuff. So written contracts, I think, always make sense. And they can take various forms. You go into a restaurant, they don't have you sign a 5-page contract. What they do is they've got a menu, which kind of spells out, what are they serving? A lot of times it's going to have, what the sides are, what the portions are, may even have nutritional information on it, the price. You order off the menu, the end of the night, you get a bill, and it reflects what you've ordered, the price that's on the menu, that kind of thing, and then adds your drinks, your tax, gratuities, that kind of thing. So between the menu and the ticket at the end of the night, that is kind of how they've done it with a contract. If you're a supplier, it can be through an invoice, you're buying things, purchase order, it can be multiple documents coupled together. So it doesn't necessarily have to be a formal contract that says, hey, this is a contract kind of thing. All right, so when we talk about contracts, and of course, if it's in writing, then any oral promises that are associated with it are unenforceable because the written contract is going to take precedence. And so we talk about 3 requirements: offer, acceptance, and consideration. And so that's why, all parties are contributing something during the process. We look at our example, somebody's manufacturing the widgets, the customer's paying the price type of thing. So that's why we say a promise to give a gift is not an enforceable contract, because there's no consideration on the part of the recipient. All right, so now somebody breaches a contract. So what's that mean? That means that they refuse to comply with the requirements of the contract. They decide to abort the contract for whatever reason. So the victim can sue the party that breached the contract, but in most cases, the court is not going to enforce that party to complete the contract. And in a lot of cases, you wouldn't necessarily want that to take place. So we have, let's say an example, the bride goes to orders a wedding cake 8 months ahead of time. And so she gets one, it's going to be $750. 3 weeks before the wedding, the baker calls and said, hey, I'm not baking cakes anymore. Forget it. Sorry. Good luck. Have a nice life type of thing. All right. So now all of a sudden, the bride has to scurry around, and to get that equivalent cake, now it's going to cost her $1,250. All right. So now if she takes the first baker to court, then what she's most likely going to win, if she wins, she'll get $500. So what that does is that puts her back in the original position that the 500 plus the 750 she was going to pay baker number 1, she gets that equivalent cake. Now, there are instances where the government may come in and they may enforce you or force you to complete contracts. And I mean, those are things like, say, in time of war, where a factory has converted from auto manufacturing to making Jeeps or tanks or airplanes, that kind of thing, that it's like, hey, the company decides, well, we're not making enough on this, we're going to go back to making cars. Well, then that may be where the government enforces them to continue to perform under the terms of the contract. But in most cases, there's probably going to be some kind of financial compensation, and that's the way it's going to be addressed. All right, so when we talk about execution, so one of the things when you form a corporation or an LLC, now any contract is going to be in the name of the organization. And when you sign your name, you're signing as an authorized representative of the organization. So it's very important that when you sign a contract, in my case, it's going to be John Donner for John's Commercial Cleaning LLC. And so I'm just signing as the authorized representative. If the contract were made out to John Donner, then if there were an issue with that contract, I wouldn't have that corporate veil of protection, because the court's going to look at, hey, the contract's with John Donner, so you're personally responsible, type of thing. And then they should be executed by individuals that are authorized by the organization to commit the company. And there's going to be a reasonable expectation that the person sitting across the table from you, when they sign the contract, that they're authorized to do so. And so that's by having it as an authorized representative in the name of the organization, that's what maintains that corporate veil of protection. So now we talk about contracts within a contract. So, Ted and I were talking before we started tonight that I've been into some meetings with regarding the new Bill Stadium. And of course, Turner Construction with Gilbane and 34 Construction, they're kind of the primes on it. There'll be a lot of subcontracts in that. And so if you're a subcontractor, a lot of the prime contract provisions will flow down, that you're going to be responsible for those as well. So, if you're issuing subcontracts, you've got to make sure that their proposals are compliant with the prime contract requirements, or the ones that pertain to them, and that allow you to enforce the terms of the contract following award. When we talk about assignment of lease, so you've got a commercial property or you've got a residential apartment, and basically you're replacing the original tenant with a replacement tenant for the balance of the lease, as opposed to a sublease, which you're going to transfer a portion of the lease space to a third party. So you might think about somebody leases a commercial space that they're going to have a salon, a beauty parlor, and they have chair rentals, and they have maybe 4 or 5 stations, and then they have a room in the back or a kiosk over on the side, and they decide to have a sublease agreement. Somebody's going to come in and they're going to do nails or something, affiliated type of business. Well, then that would fall under a sublease type of arrangement. Okay, so key contract provisions. So we talk about, defining what the product or service is. Are there recurring and non-recurring activities? What constitutes acceptance? And the reason I bring up recurring and non-recurring activities, let's think about our widgets for, 50 widgets for $400. Well, that works out to $8 a piece. Well, let's say that the client decides after 25 widgets, I don't want the balance. Well, then, he's paying the $200 for the 25 widgets. And of course, if you have any material or cost or anything like that, that would get reimbursed as well. But let's say that the development of these widgets, the development cost, the non-recurring cost was $300. And then the recurring costs on these widgets were $2 a piece. Well, now all of a sudden, 25 widgets, you've got $350 worth of cost, not $200 worth of cost. So one of the things you may do is either it's going to be addressed in a termination provision in the contract, or you might have line items for both recurring and non-recurring costs, because if you only build one widget, you would still be getting $302 at a minimum because you've completed all the development costs. We talk about compensation. Is it going to be fixed price? Is it going to be cost reimbursable? When you think about if you own a store or a restaurant, it's point of service payment. So you go in, you have dinner, you pay the bill at the end of the night. If you buy a car even, you're not driving out the dealership until you've either paid for it or, signed the loan agreement and the dealer's been paid. If you're having a house built, what's going to happen is a lot of times, if you're dealing directly with the builder, there may be a series of payments. When you sign the contract, you may pay 20%. When the foundation's done, there could be another payment. When the shell goes up, another percentage. And then there might be like a 15 or 20% withholding until that certificate of occupancy is signed and the job is completely done. So there could be milestone payments, something along that range. And then of course, we talk about if there's a termination of the contract, we go back to the widget example. And we talk about periods of performance. Is it going to be, you're going to produce 100 items and the delivery dates are these specific dates, or it could be, you have a service contract for the heating and air conditioning systems of an office building downtown, and you sign that contract, you're going to provide these services for the next 18 months or 24 months, that kind of thing. And if you're producing a product, when does that transfer of ownership occur? You hear the concept FOB origin, FOB destination, which is free on board. So it's kind of like who pays for the freight. And a part of that too is when does the transfer of ownership take place? So, if it doesn't take place until the delivery is at the buyer's location, if it's damaged in transport, it's going to be the manufacturer that's going to be responsible. If it's FOB origin and it gets damaged in transport, it's going to be the buyer's responsibility. So it's something that you need to think about. So we talk about indemnity and guarantee. They're similar, but like my late mother-in-law used to say with chess and checkers, they're the same, but they're different. If you look at indemnity, that's really an agreement to pay or reimburse for a loss. So you look at the guy that's the building contractor. He may be the general contractor, but maybe he subcontracts the plumbing. If there's a problem with the plumbing, the person that bought the house from him, they're going to call him, and it's going to be up to him that sees that it gets fixed. But then the plumber is going to either reimburse them or he's going to be the guy that goes out and fixes it. So that's what an indemnity is, as opposed to a guarantee, which is an agreement to meet an obligation of someone else. So think of the LLC owner, basically the personal guarantee, the co-signing for the business with the business loan, or the personal guarantee for the commercial lease, that kind of thing. Insurance, if you get into something where it's a lease space, there's going to be insurance requirements for both the landlord and the tenant. When we talk about notice of default, if a party defaults on the contract, you need to have a written notice and a cure period before the legal action can happen. Think about somebody that is leasing an apartment. Let's say there's a death in the family and they're out of town for a couple of weeks. They don't get back till the 10th of, they get back today, the 12th of December. Their rent was due the, Friday, which was what, the 9th. And, they weren't in town, so they weren't able to pay it. And they come home, and because their rent's overdue, they come home and the locks are changed and all their stuff's out in the front yard. Well, that's not reasonable. So what you have is you have a notice and a cure period that would allow that to take place. Termination, there's going to be certain circumstances in a contract agreement where it makes sense for one party or the other to terminate. Government contract, the funding goes away, the requirement goes away, technology has changed, something like that. They want to terminate the contract. Well, then for the contractor, they should be reimbursed for anything they've delivered and all the expenses that they have incurred to date. And there might be part of the component might be that they'll get some kind of settlement for the missed profit, that kind of thing, but that's kind of a rare occurrence in a termination. We talked about indemnity. When we talk about disputes, you don't want to go directly to court. The first thing would be, okay, let's go to non-binding mediation. And if the first thing we would do is let's have the two parties sit down and discuss it. Then the second thing would be go to non-binding mediation, then go to arbitration, then go to court, not just jump directly to file complaint and start suing the person. Let's see if we can work it out first. When we talk about additional agreements, sometimes, especially when you get into government contracts, I've had instances where the government contract might be 250 pages long, and there could be a couple thousand pages of attachments, and it could be the full language of like federal acquisition regulations, cost accounting standards, that kind of thing, technical specifications. There could be sheets that say, let's say you have to have a crew on site at like an air base or a naval installation or something like that, where maybe they have to have a certain security clearance, or at least they have to have ID badges and have some initial clearances and have some background checks and things like that. So there might be a list of the employees, their employee number, what their position is, that kind of thing. And so, those are things that are kind of fluid. People leave, people come, requirements change, so that you're not going to amend the whole contract. What you'll do is you'll have that attachment will get updated, and the amendment would just be a one page that says this attachment's changed, that kind of thing. So, rather than embedded in the language of the contract itself, it's an attachment because that's less of an administrative burden to address it in that way. Additional provisions, we talk about entire agreements. So that says that, the language in this document includes the entire agreement, supersedes all previously written and oral agreements. Notices, again, we talk about defaults, cure periods, that kind of thing. So you'll have in there for each party, who do you contact? And nowadays it's probably a name, address, phone number, email, so that you can get a hold of that person. Governing law, you need to state what jurisdiction it applies to. So for most of us, our contracts, we're going to say New York law applies. And that's important to have in there because New York laws are different than New Jersey's laws or Pennsylvania's laws. And if, court's not going to enforce a contract that doesn't have a jurisdiction called out because they don't know what laws to apply to the contract. So it's important we call that out. We talk about counterparts. You could have a contract that, requires 8 signatures. And now you have things like DocuSign in that, but we've seen, with the whole pandemic thing where people are working remotely, that what they'll do is, let's say there's 8 signatures required. And so you've got the agreement, and then attached to it are 8 different signature sheets, and each one has one of the signatures on it. Well, you're going to accept those signatures as if they were all physically on the same page. We talk about modifications. They're going to be only when they're done in writing, signed by the parties to the contract. We talk about waivers. Once in a while, a term may be waived. And again, a waiver is a one-time deal. It doesn't mean that from here on out, let's say, a lease. This month, instead of paying on the 10th, they'll allow you to pay on the 15th. But that doesn't mean now automatically every month the rent's due on the 15th. Next month, it's go back to the 10th. A waiver is going to be a one kind of deal. And then we talk about severability. Years ago, maybe the laws change or something happens, and maybe there's a provision in the contract that is unenforceable now or illegal. And so, somebody go to the court and say, hey, we want this contract thrown out because it's an illegal contract. Well, the severability provision says, if one or more provisions are found to be unenforceable or illegal, the court will treat those provisions as if they are not part of the contract, severing them from the contract, and then they'll enforce the balance of the contract. So that's why you see those kind of terms in there, why they're used. All right. So any questions on basic contracts, Ted?
Nothing new in the chat, John.
Okay, so we'll go over to lease. And lease really is a type of contract where you're paying money for the exclusive use of a space. Or, you're paying money on a monthly basis for the use of a truck. Or from a personal standpoint, you're leasing a car, that kind of thing. So exclusive use, whether you use it or not, you have the exclusive right to use it during that time period. So what do we look at? We look at the term or the length of the lease, the responsibility for repairs and utilities. Okay, is an assignment or a sublease allowed? We talked about that before. And ordinarily, but only in writing, and it won't necessarily unnecessarily be denied type of thing. Then we look at the space that you're renting. Does it meet the necessary permitting and or zoning requirements? And is the space physically ready to use? So those are kind of the main considerations. So now we look at provisions. So the first thing we look at is the names of the parties. We already talked about it in contracts. If you have a organization, the lease is going to be in the name of the organization, and you're signing as an authorized individual. Again, if I sign the lease as John Donner, then I'm personally responsible for it. Now, I may in the long term be, if I have a personal guarantee, I would be the secondary responsible party on it. The address of the premises being leased, clearly defined. It's here at Roach, Lennon and Brown. We're on the 10th floor and we have some of the 6th floor of the electric building. Well, our official address is 535 Washington Street, Suite 1000. So that's, what we would want to, that's how it's recognized in the building. And so that's what we want it to be. Is there a suite or something like that associated with it? The other thing that I've seen is that you have a building that's on a corner. And the lease says 123 Main Street, and it's at the corner of Maple, and you go down to City Hall and they say, well, we don't have any record of 123 Main Street. And they say, oh, wait a minute, that's 456 Maple Street, kind of thing. So you have to look at that, and you would be amazed at how many leases I've reviewed that there's an error on the address or it's not clearly defined space. The length of the lease, is there a base period? Are there options? Are there different points in time where there's opportunities to exit the lease without penalty? Nowadays, rather than sign a 5-year lease or a 7-year lease, especially if you're just starting out a build with a business, you might want to sign a 2-year lease that has 3 1-year options rather than a 5-year lease where you're right out of the gate responsible for the full 5 years. And we talk about rent. What's the frequency? Typically, it's going to be once a month. I mean, sometimes you occasionally see a lease where it's a semi-annual payment, and kind of like car insurance. If you pay for it 6 months at a time, it oftentimes will cost you less than if you pay on monthly installments type of thing. There could be a base rent, and then you have to look, are there secondary rents? So there might be the rent's $1,000 a month, and then later on in the lease, they talk about this additional payment where you're paying a prorated share of property taxes, maintenance and cleaning services, things like that. So it could be a secondary rent payment as well. So you have to look at that. And then there should be a payment schedule. If it's a 36-month lease, especially if there's an escalation, it should show, months 1 through 12 are $1,000, months 13 through 24 are $1,100, 25 through 36 are $1,150, or whatever it is, that kind of thing. Security deposits, it used to be, last month rental plus security deposits. So it was typically 3 months rent that you would pay when you sign the lease type of thing. So what is the amount? When's the date due? Is it when you sign the lease or within 30 days or before you take occupancy? When would it be returned at the end of the lease? Conditions under which deductions to the deposit would be made, that kind of thing. And then finally, insurance. The lease is going to call out insurance requirements. And you're typically going to have, they'll ask for a certificate of insurance, and that's kind of the commercial, building or business equivalent of the insurance card that you carry in the glove compartment of your car if you don't have it on your phone, type of thing. And with a landlord-tenant relationship, you're going to have policy requirements for both parties. So obviously, as a tenant, you're going to have insurance that covers the landlord, but the landlord's also going to have insurance that covers the tenant. Because you look at, okay, what happens if the building collapses or there's a fire that has nothing to do with you? Then the landlord would be responsible, their insurance, for covering your losses, as opposed to, let's say you start a fire in your shop and it carries on through the whole building, then your insurance could be responsible for the landlord for those damages that were, your responsibility, that kind of thing. So it has to work both ways. And we talk about other things like improvements by the landlord or the tenant. Typically, if it's something that's, an improvement to the leased premises, it's going to remain. The exception would be you put all these elaborate light fixtures up. The solution might be that you save the old fixtures, and when you get ready to leave, you take yours down, you put the old ones back, so that you leave it at least in the same condition that when you rented the place. Use of the premises. So they talk about quiet use, that you should be able to use it for the intended use. But again, you're going to have to look at, make sure. I've had a couple instances where, the landlord didn't even know what the permitting and the zoning requirements for the building were. And then the person signs a lease, and then they go down to City Hall. Oh, you can't use it for that. It's not zoned for that. It's not a permitted use type of thing. What representations does the landlord make, to the, the life of, where they are, is it recently replaced electrical or new heating and air conditioning, that kind of thing. What are the representations and the soundness of the building, things like that. Utilities and services, is the space separately metered, or is it prorated by percentage of square footage that you're leasing? A lot of times you may find a mixture where, you're renting 1,000 square feet and it's been carved out as a suite of offices. And so it has a separate electric meter, it has a separate gas meter, but the water is shared throughout the building. And then they just kind of prorate it. That's fine if everybody's use is fairly equivalent. But let's say, you've got a income tax preparation service and you're renting half of the first floor, and the other tenant who's renting the same size space, they've got a car wash. Well, their use of water is going to be a lot different than that half bath that you have. The toilet gets flushed half a dozen times a day, and the coffee pot gets filled from the sink a couple of times. So you have to look at, are there potential issues there? Maintenance and repairs. Typically, the landlord's going to be responsible for the overall structure, and you're going to be responsible for your space. I've seen where landlords are now going to make you responsible for the maintenance and repair of like heating and air conditioning systems. If that's the case, what is the condition when you move in, and is that unit dedicated to the space you're renting? We talked about subletting and assignment. Usually it's and it has to have the prior written approval of the landlord, but they won't unreasonably deny it. Damage to the premises, who's responsible for it? If it's something that had nothing to do with the tenant's use, then they're gonna the landlord is going to be responsible. If you start a kitchen fire and it spreads to the building, you're going to be responsible for that. We talk about the quiet enjoyment. That means being able to use it for what you wanted, that you leased it for, so you can use it for the purposes you wanted. And then we talk finally about holding over, and that most often takes place you're in the process of negotiating the next lease and the first one expires. So then what they do is say that the existing lease is going to carry over on a month-to-month basis until the new lease is negotiated. All right, so anything on leases? Good, I'll take that as a no, Ted. So now we're going to
No,
talk
no, it's not.
about, sure, anything there, Ted?
Yeah, there's nothing, nothing
Okay.
additional, John.
So now we're going to talk about employees versus independent contractors. So let's take an example. Luigi owns a restaurant. His staff consists of the following individual. He's got a full-time cook. He's got a part-time cook. He's got 2 full-time wait staff, 3 part-time wait staff. He's got 4 part-time dishwashers, busing staff. He's got a hostess that comes in. She works 4 hours on Friday, 4 hours on Saturday. Got 1 full-time bartender. You got your sister's kid who shows up about 4 hours a month when he shows up. You've got a retired CPA who's assisting you with the books. And due to staffing issues and difficulties finding employees, he's hired a part-time bartender through a staffing agency for the holiday season. Now, one Friday evening, it's about 4:30, the shift's just starting. The dishwasher quits. A plumber's called in to fix the problems. So we look at it, we say, okay, what's the employment status of each one of the parties we just talked about? All right, so let's start out with the easy one. The plumber's an independent contractor. They call him in, fix it. I don't care how you fix it, just fix it. He comes in, he brings in his own tools, his own expertise. You don't negotiate with him how he's going to fix it, other than fix it right or fix it temporarily, but you're not going to tell him, well, I wouldn't use that pipe, I'd use this pipe, type of thing. Then we look at the retired CPA. He might be a part-time employee, he might be an independent contractor. If this is the only gig he's got, that he might be a part-time employee. If he's working with several restaurants in his retirement, or he has a written agreement and it's a business-to-business relationship, then he's more than likely going to be an independent contractor. The part-time bartender from the staffing agency, kind of cop out here and say that he's neither an employee nor an independent contractor because there's no agreement between the individual and Luigi. It's just purely a contractual agreement between the staffing agency and the restaurant. It's kind of a faceless contract. But, if you were saying those are the 2 choices, you would say that's going to be an independent contractor because he's an employee of the staffing agency. The staffing agency is going to pay his benefits, his Social Security component of it, that kind of thing. And then all the other parties are going to be considered as employees, whether they're full-time, part-time, seasonal, temporary. And I mean, you see that, especially this time of year, maybe not as much this year, but I mean, other years where UPS, Amazon, Target, Walmart, they're hiring people for the next month. And so you come in, you sign up, you're working, you get your paycheck at the end of the week. They're taking out Social Security, workers' comp, disability, state and federal withholding, all that kind of stuff. You're considered an employee, even though it's temporary or seasonal, but the duration has nothing to do with it. So how do we determine, whether you're an employee or an independent contractor? So we look at, okay, how does the IRS look at it? And so we look at the relationship between the worker and the business. So, the determination of whether it's an employee or an independent contractor, what they're going to factor is what is the degree of control or independence that worker has. And so when we look at degrees of control or independence, it falls into 3 categories. So we talk about behavioral control, we talk about financial control, and we talk about the type of relationship between the parties. So when we talk about behavior control, so what kind of direction or instructions does the business give to the workers? So we look at when and where to do the work, what tools or equipment to use, what workers to hire or to assist with the work, where to purchase the supplies and services, what work must be performed by a specific individual, what order or sequence to follow. So you look at, our example, and you can see where under the plumber is going to be independent on a lot of these type of issues. I mean, obviously, when and where to do the work is going to be controlled by the restaurant because the dishwasher's in the kitchen, it's broken, it needs to be fixed now. But the restaurant isn't going to dictate what tools or equipment to use, what one of your staff members you bring in to help you, where you've bought the plumbing supplies or other services, and, what work, you bring somebody with you who's doing what work, that's all up to you. The restaurant has no input into that. Whereas you look at, in the case of the restaurant, the person that's a waiter, or the person that's a bartender, or the person that's a hostess, they're going to be operating to the direction of the owner of the restaurant in terms of how they want things done, where you're going to be, how you're going to handle it, that kind of thing. So that's what we talk about. And then part of it too is what training that the business gives to the worker. And that is kind of specific to more jobs that, a lot of the, what I'll call non-professional businesses where let's say you're going to be a cashier at a supermarket or something like that. There's going to be some training courses involved in that kind of thing. And so, I mean, that once they've invested that training, a lot of times, you're hired at Wegmans, or you're hired, my youngest son graduated from college and he's a financial analyst. And the first couple of weeks he was there, it was purely training. This is the software we use, and this is the processes we follow, that kind of thing. So, but a lot of times, you go to a business like you're an engineer or something like that, they're going to sit you down at your desk, they're going to give you some work to do. And, there may be some, HR comes and they talk to you for a day. These are the forms you got to fill out. These are the general guidelines, the working hours, that kind of thing. But beyond that, they're relying on your skill set, and they're going to let you operate at your pace, type of thing. All right, so then we talk about financial control. So to what extent does a worker have unreimbursed business expenses? If you look at, if you work for a business and you travel and you use your car, they're going to reimburse you at the IRS rate for mileage, or they might have another policy on how they reimburse you. Or if you're traveling, they're going to reimburse you for your hotel, or they're going to arrange for it up front. Same with your airfare, your train ticket, your bus ticket, rental car, whatever it's going to be, per diem, meals, that kind of stuff. They're going to reimburse you for that. Versus the plumber, he's got that hourly rate or fixed rate that he's going to charge you for repairing something. And he's not going to send you a bill that, hey, I drove my truck 20 miles, or there's these additional expendable supplies like flux and solder and things like that, that it's all going to be built into the price. Then we talk about the extent of the worker's investment. So again, you talk about the plumber who has the master plumber's license, he's got the equipment, he's got the truck, all that kind of stuff. To the extent to which the worker makes his or her services available to the relevant market. Again, to the plumber, you're just one job that day, as opposed to, you're working in the restaurant, that is your job. At least you may have other jobs, but for the 6 or 8 hours you're there, that's your primary job, type of thing. How does the business pay the worker? Is it going to be a regular wage versus a flat fee, or some kind of time and material basis for the job? And to the extent to which the worker can realize a profit or loss. You look at the plumber, some jobs he may make money if he's quoted it at a flat rate. Other jobs he may lose money. The person that works for the restaurant, they're getting an hourly wage, and they might be getting tips on top of that, depending on what their job is. Well, that, you could say they have a personal profit or loss depending on what their bills are that week, but it has nothing to do with what their income is going to be from that job. So again, they really can't realize a profit or a loss. They know if they work 10 hours and they're making $20 an hour, that's going to be $200 less FICA and all the other withholdings in it. All right, type of relationship, is there a written contract describing the relationship between the parties? So, in the case of the plumber, the contract may be just a one-page estimate. This is what I'm doing. Okay, do it. They sign that also serves as the invoice, that kind of thing. Or it could be a formal contract, and then again, sometimes you work for, let's say a manufacturer, you might sign an employment contract and it spells out the things that you do. Whether or not the business provides the worker with employee benefits, health insurance, pension plan, vacation, sick pay, that kind of thing. The permanency of the relationship. Is it an indefinite period? In New York, like a lot of states, it's an at-will thing, so it's not guaranteed forever, but they're hiring you to fill a position as opposed to we have this project for the next 3 weeks or a month or something like that. And then the extent to which the services performed by the worker are a key aspect of the regular business of the company. So we look at, you have the restaurant. So yeah, key players, the guy that cooks, the bartender, the server, that kind of stuff. The plumber, he's not related to a key aspect of the regular business of the company. Is it important that the dishwasher works? Of course it is. But having a plumber on staff isn't a necessity type of thing. Okay. Any questions on employees versus independent contractors?
There is one.
Okay.
Can you explain how and when the CE 200 waiver form gets implemented when dealing with family as employees?
Is that the waiver for workers' comp and disability? The individual?
I'm not sure.
Because in some cases, the only time you would have, like for workers' comp and disability, there's a waiver if you're a member of an LLC, because they treat you as a member as opposed to an employee. Now, if you decide you're going to be paid as an employee and you're going to get a regular paycheck with the withholdings in that, then you're going to have that workers' comp and disability is going to be a requirement. So they have to look at the specific circumstances and see, what's there. All right.
Okay, and the Tyler says, I believe the CE 200 waiver is the one that you mentioned, Jen.
Okay, yeah, and that's something they can go over to the Department of Labor office and yeah, if they're a member versus an employee, then you can get a waiver for the workers' comp and the disability. And it's important that you get that waiver and have it on record. I've seen that with a number of my clients that they go and they do that if they're going to be a member or partner in the business type of thing. They get that waiver because they look at it, it's an owner of the business versus an employee. But the downside, okay, so now you don't have to pay for that. But the downside of it is if you get injured on or off the job, you're not part of either of those programs. So you can't collect against it either. So it's kind of a catch-22 type of thing. So you have to look at, what the risk and reward is there. All right, so let's go over to license and permits. So there is no nationwide standard. Every state, county, municipality is going to have their own specific requirements. And depending on the type of business and the products and services you provide, there might be federal requirements. So let's talk about licenses. So they're granted by a government agency, allow you to perform, sell, use certain products or services. So you think about, typically at the state level. So you could say, a license to practice law. My license is in New York. If you're a licensed professional engineer, it's going to be a New York-based license. You can be licensed in other states, but there's certain testing, hours of service, that kind of thing that you have to meet. Sometimes you have to have a license to either purchase or manufacture certain products. So we look at manufacture of alcohol, guns, ammunition, tobacco, those kind of things where you're going to have federal agencies involved. It depending on, the manufacturing process and the materials required and the waste as a result of manufacturing, there might also be some permitting at the local municipal level or the county besides the state type of thing. But they're really kind of a long-term based on the requirements that there's a license. Where you look at a permit, it's kind of like a type of license, but it's limited in scope. So a lot of times a permit could be linked to a specific location or event. So there might be an organization that has a holiday farmers market. And so they're going to have a permit with the city of Buffalo, or maybe with the county, or it could be the town of Wheatfield or something, depending on where it is, but it's going to be for a specific date and time, location, specific scope of services, kind of a one-time deal type of thing. And then the permit could be in connection with public safety, because let's say you have, you get a permit for, say, something like the turkey trot, at Thanksgiving, the run where you got 20,000 individuals running whatever it is, 5K or whatever it is. And so as part of that permit, then you have public safety out there where they're blocking off streets and they've got cones and the whole infrastructure. They have first responders available, that kind of thing. So, I mean, that is another reason for a permit, is that they look at what the scope of the event is and what they need to have in place to properly service it, type of thing. And typically the permits are going to be issued at the local level. You're not going to get a state permit for the turkey trot, or you're not going to get a federal permit. It's going to be the city of Buffalo, because they're going to be the ones involved in whatever their part of it is as well. So that's kind of the difference between the two. All right, so we talk about federal licenses, permits. So, typically it's going to be dealing with, the type of products or services or the nature of them. So when we look at, for example, the U.S. Department of Agriculture, typically it's going to be like the import or transport of animals and animal products and plants. And a lot of times it's going to be like across state lines type of thing. But then the other thing they're involved in, where local small businesses might be involved, is, let's say that you open up an ethnic market and it's in a depressed neighborhood. Well, then you may want to be a participant in the food stamp program, and that's administered. The Supplemental Nutritional Assistance Program, or SNAP, is administered by the U.S. Department of Agriculture, because they would come in, they would audit. There's certain limitations. So there are variances if you're the only market available for a certain geographic area. But typically what they're going to require is they're going to have so many stocking units of different types of provisions, that kind of thing. And they're going to do an audit. And if you don't meet those requirements, they're not going to let you join the program. And it takes 6 months before you can go for another audit type of thing, because part of that is they're going to give you all the card readers and everything else to take to scan the EBT cards, that kind of thing. We look at alcohol and tobacco, obviously, because of, we'll call inherent dangers, or the impairments that can happen because of alcohol, tobacco, those kind of things, and the health issues, secondary health issues that, it's treated at the federal level. If you're doing any kind of business broadcast by radio, television and such, then the Federal Communications Commission is likely going to be involved. If you are compensated for providing securities advice, then you're going to register as a advisor with the Securities and Exchange Commission. When we look at the U.S. Food and Drug Administrative, all right, it's going to regulate foods and food ingredients offered for interstate commerce. Now it says with exception, there's certain products that are going to be regulated by the USDA. And then there are some, in addition to the FDA, it may be the Erie County Health Department or something like that would issue like the permits at like a restaurant level, that kind of thing, food truck, catering service, that kind of thing. IRS, besides income taxes, when you form an LLC or a corporation or even a partnership, you're going to go online, you're going to get an employer identification number, which is basically the equivalent of a social security number for your business. And we talk about, state permits for nearly all businesses. If you're filing as a LLC, a corporation, a nonprofit, any derivatives like a PLLC, a PC, that kind of thing, the filing of the business organization is going to go through the Department of State. Then there's also about 15 different types of businesses that, barbers and various others that, security services, appearance enhancements. So that can be, tattoo parlors, things like that, where if you go to the Department of State website, it shows the particular regulations that are associated with that. When we get into the professional services, where we talked about the PLLCs and the PCs, the New York State Education Department Office of the Professions, they handle that. And there's about 50 different occupations when you go onto their site and you look at that. And actually, when you form a PLLC or a PC, you first submit the proposed articles of organization or certificate of incorporation to the New York State Education Department for approval before it gets submitted to the Department of State. So they play a very active part in that. Obviously, if you're going to make or sell alcoholic beverages, New York State Liquor Authority is going to be involved. And of course, the New York State Department of Taxation and Finance. So you talk about sales tax, employment taxes. If you're selling and you have to collect sales tax, you have to file with them to get a certificate of authority to collect sales tax. And then if you're forming an LLC or a PLLC, within a week or so of filing with the Department of State and getting an EIN number, they're going to send you a form called a TR 570, which is an LLC LLP request for information. All right. Then we talk about municipal licenses and permits, the local ones. So when you think about, you want to open up a business in the city of Buffalo, well, you may have to go down to the licenses and permits department and get it filed for a general business license. If you're like in the skilled trades, they require, if you're going to do electrical work or plumbing work, that you're licensed as or certified as a master electrician or a master plumber. Food or drink, you're going to deal with the health department in terms of you lease a facility. You're going to check with the city to see if it's zoned. And when you think about zoning, it's typically going to be, is it commercial area, residential, mixed use, that kind of thing. Whereas permitted use is going to be specific to the building type of thing. So it could be in a commercial zone, but that particular building is just for light storage and office. You can't use it for other uses because maybe the structure of the building or something along those lines. Then there could be miscellaneous permits. You see that in a lot of these neighborhoods, they have a theme. And so, it might be a local preservation board. And so, there could be a half a dozen blocks on Elmwood where they're all matching awnings, that kind of thing. So there might be these other local board requirements. So it is similar to, homeowners associations or condo associations, where if you want to do something, it has to go through them, or it has to meet a certain standard or look a certain way or use a certain vendor. So a lot of times there can be instances for a business, similar things like signage and things like that. Then finally, if instead of filing as a corporation or an LLC, you're going for an informal business structure like a sole proprietorship or a partnership, you're going to do that filing at the county clerk's office. All right, so now just kind of an example. So, a lot of times when small businesses decide they're going to start a small business, we do everything. Well, one of the problems with that is if you do everything, you probably don't do anything exceptionally well. And so, you have to look at least starting out, do you want to kind of contain your enthusiasm and the scope of services and products to focus on something, and then you can always expand down the road. But in this case, we have a person that wants to open a restaurant that serves alcohol, catering, they're going to have live entertainment, they also want a food truck type of thing. So look at, under a situation like that, what kind of permits and licenses will we be looking at? So you look at first at the top are kind of like the organizational things that regardless of the type of business you're going to need. So there's going to be some kind of organizational filing. Is it going to be an LLC, a corporation, a sole proprietorship, a partnership? Then you're going to get an employee identification number from the IRS. Most likely in this case, you're going to have to charge sales tax on some, if not all of the items that you're selling. So you're going to have to get, the certificate of authority to collect sales tax, a reseller's permit, so that you're not paying tax on the supplies and services you're buying because you're taxing them as part of your sale, so that the state can't benefit by getting double the sales tax. The way they get around that is that you're going to get a reseller certificate, so you're excluded from paying sales tax, and then you're collecting the sales tax on your materials when it goes out the door as a finished product type of thing. Might be a seller's permit requirement. You're going to have to, for what you're doing, verify that the building you're leasing meets the zoning and the permitted use requirements. You're going to have to get a certificate of occupancy, depending on where you are. If you want special signage, you're going to have to get that. Same thing, you want to do an outdoor patio or something like that. It's going to be, is there a requirement from the city you have to fulfill? Sometimes, depending on the location, you might even have to have a license for having a dumpster there. Obviously, as a restaurant, there's going to be a health permit and the inspections of the building, the kitchen, that kind of thing. Food service license, a food handler's permit, a liquor license because you're selling alcohol. There could be some kind of live entertainment or music license. Among other things, what it does is it allows maybe, it curtails to what's the occupancy, the limited number of occupants of the building, hours of operation for live entertainment, whether it could be outside, it's inside, noise levels, that kind of thing. If parking's a problem, maybe you're looking at having a valet parking service. Well, then there might be a municipal permit associated with that, along with agreements of, a local parking lot or a parking ramp, something like that. And then food truck is going to be its own separate thing where it's going to have to meet, health department standards, everything else. And like the city of Buffalo, the annual fee, I think, is $800 for a food truck permit. So you look at this and you say, wow, starting out, it's kind of an overwhelming list. So what you may want to do, and I say a logical approach to address the permits and licensing requirements, is that you start out and you work with a SCORE mentor, a business advisor at the SBDC, the Women's Business Center, Beverly Gray, wherever you're working with, to kind of, what do I want to do? Develop that preliminary business plan. Then at that point in time, that's when you want to form your business entity, because as you go through and you get these permits and licenses, you open up the bank accounts, you enter into contracts, you want all that to be in the name of the business. So you want to have the business formed before that. Then what you could do is we look at, on the previous slide, that long list of things we'd have to do, look and kind of reevaluate the plan with respect to cost and other requirements, including the permits, the licenses, the capital, the insurance, the contracts, the number of employees, the other variables that you need to do with this, because you could put a lot of your effort into one aspect of it and then find out that it only represents, 5% of your sales or something like that. So you look at things like, and so now we look at revise the business plan as necessary and start to execute a properly scaled model of the business. And then, you get those particular licenses and permits that you require. And then if you decide you want to add more services in or expand the business, then you can look at what other license and permits and insurance requirements and other costs are associated with that and move on. You think about locally, one of the startups from maybe 10 years ago, Lloyd's Taco Truck. They started with one food truck, then they expanded to several. Then after that, they expanded into several brick and mortar locations as well. But it all started out with one food truck first to see, a much lower investment to see would it take off? Will people even want to buy tacos in Buffalo before you have these grand and glorious plans that we're going to open up this 50,000 square foot banquet hall, and then we're going to do all these other things where you don't know whether it's going to take off or not. They took a more pragmatic approach and let's start out with a food truck first. And if that works out, maybe we'll get a second one. And then we can, you find such a following that the limitations with a food truck, because you're not going to get the people out there when the weather's bad or like food truck season's over. So you don't have any food trucks out there right now. I mean, possibly for a special event or something like that. But, so now maybe it makes sense to have a year-round restaurant kind of thing. So you have to look at it from a kind of a progressive standpoint that you don't bite off more than you can chew right out of the gate. Okay, so now we'll head over to intellectual property unless there's anything else.
No additional questions in the chat at this point.
Good. So by now I've probably put everybody to sleep. That's why we're not getting any questions. So, all right. So we'll talk about intellectual property. And like what I said when I first started speaking tonight, that a lot of you probably have businesses where you're not going to have patents. You might have trademarks or service marks. If it's an artistic oriented business, you may have some copyrights. But for a lot of people, they may have trade secrets or company confidential information. And so they want to look at, what kind of controls they can put in place to kind of, keep that information private. All right, so let's talk about trade secrets. So, what are the characteristics? Well, it's not going to be general knowledge, or easily, routinely ascertainable. There's some kind of development involved, that kind of thing. Has some kind of value commercially, and it gives the organization some kind of economic advantage in that, what makes us better than the competition type of thing. And then this kind of information, it's going to be guarded through some kind of reasonable means to maintain its secrecy. So, let's talk about items that you would generally consider trade secrets. So we talk about technical information and know-how. So it could be technical specifications, it could be specific designs for your products, it could be formulas. In some cases, you might have developed some software tools or something like that is part of your processes. It could be manufacturing techniques, and it could be something that kind of involves all of those, that it's some kind of specific proprietary knowledge on how to do something better, faster, cheaper, that kind of thing. And then business information, financial data, you can mine a lot of it over the internet nowadays. I mean, if you're publicly traded, you're going to have annual reports that have a lot of that kind of stuff. But there's other financial data that would be, company confidential. What are your overhead rates? What are your labor rates? Labor classifications, that kind of thing. Components that are critical when you're providing competitive bids, that kind of thing. Market research, again, 30 years ago, you'd go out, you'd hire a market research firm and they'd do all kinds of studies and prepare reports. Nowadays, a lot of this, we could go over to the public library and book a librarian for an hour, and they have researched all these databases and they could probably come up with that same kind of analysis. So, there could be some research that you've done that you want to have of a proprietary nature and protect. But, it's probably going to be very specific to a very unique market or something like that. But again, information you probably want to protect. Obviously, customer and vendor lists. Anybody can create a list. You see those internet listings for $59.95. We'll sit down with your business, we'll develop vendor lists and things like that. Well, they're just doing a generic internet search. Whereas a lot of these businesses over the years, they've developed customer relationships or vendor relationships. And so they have specific ones they want to use for different aspects of their business. And then you could have things, unannounced business negotiations. You could be in merger agreements with another business that if you're going to be taking them over, it could expand your market, or maybe they have some unique technologies or something like that, that's information that could be valuable in terms of your stock price and things like that. But again, it's something that you want to hold, protect that and not let that necessarily become public knowledge right away. All right, so how do we protect trade secrets? So part of it can be you kind of divulge to even your employees on kind of a need to know basis. The other thing that you can do is you can mark these documents as proprietary or company confidential. And the reason I say, and then we talk about use of confidentiality and non-disclosure agreements. And the reason I bring this up is that when you do government contracting, especially if you're a prime contractor, a lot of times when you submit your proposal, if it's for a major contract, you're also going to have to submit proposals to your subcontractors. And those proposals are going to have proprietary information where it's going to have their rates, their labor categories, things like that. And in some cases, what happens is that the submission that you get from the subcontractor is going to have all the generic information, and the proprietary information gets sent directly to the government. And so then that's how they kind of handle it that way, because that's stuff that kind of just, what makes them different from the competition, and they don't want that to get out in the public. And then, like I said, the way the team members would address it then is all the players would sign confidentiality and non-disclosure agreements, because every once in a while, what happens is that that prime contractor may get that proprietary information inadvertently. It gets sent back by the government to you instead of the subcontractor type of thing. So then, you just have to follow the spirit of these agreements and just say, oh, I can't look at this, bundle it up, send it back to the subcontractor, and that's it. And I've had circumstances like that. You're going to keep the information out of the public view. You're going to place the information in restricted areas or grant restricted access. Or, if you work for a business, a lot of times you have access to some of the business information, but only the business information that pertains to your job. So, and you get into that, especially if you're in the government contracting. I spent almost 25 years in aerospace and defense. And for about 18 years, I had government secret clearance. And at that point in time, sorry about that. At that point in time, there were certain documents that if you didn't have the proper clearances, you couldn't view them anyway. So, those kind of things, I would kind of protect our company confidential information. All right, so now let's talk about trademark. So we think about things like, Apple's, the apple with the one bite out of it, or Nike has the swoosh, or Ford has the blue oval, or GM has the bow tie, things that we see that symbol and we know what the brand is without even the name being there, type of thing. So it identifies the brand, distinguishes the goods from those of others. So we say it enables a consumer to identify a product and its source. And so now you have state and federal sources of trademark law. So how do you protect that image? And so then related to trademark is you have service marks, which are used by companies to identify services rather than a product type of thing. They're almost interchangeable. You have collective marks, which are something different, and usually that is tied more like memberships. So for example, National Contract Management Association, they have different contract certifications, and you get put these letters after your name if you've met one of those certifications. So that's a distinguishing membership. And the collective mark, maybe the National Contract Management Association has trademarked those terms. Then you also have certification marks. So you think, it started out about 30 years ago with the international standards, the ISO standards, which were the replacement for the old mil-spec standards. And so ISO 9000, things like that, or year 2000 certified, things like that, where you'd go through and there would be maybe some process review and things like that, that once you met that criterion, then you got that certification. So especially the ISO, you still see periodically a manufacturing facility where they've got a flag flying out on the flagpole that says, we're ISO XYZ type of thing. So that's kind of like a certification mark. All right, so elements of a trademark. So it's got to have this distinctiveness, when you look at the Nike swoosh, you know what it is, or you see that Apple logo, or you see the Ford logo, you know what it is. And then they use it as well. So you look at that. So when we talk about trademark registration, and we do that here. Chris Brown, one of the partners, he does a lot of the intellectual property. And if you want to register a trademark nowadays, just because of the manpower in a lot of these agencies and the review process, nowadays it probably takes about a year. And you're talking somewhere about $1,500 to register a trademark. So what they do is, they'll do an examination. Is it too close to something else? Or can they issue it, type of thing? So they look at that. And then, if you've registered it, then that gives you the exclusive right to use that mark in commerce. And if you find somebody that is using something very close to it or identical to it, then you can issue a cease and desist order. And if they don't abide by that order, then you can sue them for using your mark. And then a lot of times when you go through and you look at the trademark listings, a lot of times businesses don't want to pay the annual fees and things like that. The life of it's lived its life kind of thing. So you'll see a lot of times that they'll cancel the trademark, and then it either becomes abandoned, or in some cases, a mark might become generic. And so when we think about manufacturers that have fought very hard to keep from making their product or their trademark or their name generic, you think about a Kleenex brand. And Kleenex is actually a brand of facial tissue, but people talk about Kleenex all the time. Or, a copy machine, the old school people might still call it a Xerox machine. kind of thing. Or Windex is window cleaner, but Windex is a brand, but that's generically how people refer to it oftentimes, type of thing. So you have to look at those kind of things that, how is it addressed? Then we talk about copyrights. And so this would be more if you're kind of like an artisan. So we talk about literary, dramatic, musical artworks, that kind of thing. And then, what's interesting now, and you wonder if years from now it'll change, is computer software is still in there. And so we look at that being maybe because you can have design components and things like that. But, it's kind of broad-based. And then in 1976, the Copyright Act has where upon creation, copyright automatically attaches to the work. So you could say that the formal registration process kind of isn't as fundamental as it used to be. But the problem is you still, if you want to copyright an image, the formality of the publication, the registration, the other steps, it's important because you want to show that you formally registered the copyright, so that if there's an infringement, it allows you then to take the offending party to court. So if you're a copyright holder, what rights do you have? So, no one else can make an unauthorized copy. You've got the rights to derivative works. And that's why you see oftentimes if a book is made into a movie or a TV movie or a TV show or something like that, they talk about first that the studio has to get the rights from the original author, that kind of thing. Or it's the same thing if they want to use a song in the soundtrack, that kind of thing. So they have to go back to the original source and get permission to do that. Again, right to distribution prevents others from selling, renting, leasing, lending, that kind of thing. And we have something called the first sale document, that once a copyright article is sold without restriction, then there's no further restrictions, so it's, you look at a lot of artists, you've seen even top level artists like, Neil Young or Elton John or other groups, where Bob Dylan, where they've sold their music catalogs to, a corporation. And now the corporation can distribute it how they want to do that, type of thing. The right to performance. So it prevents others from publicly performing the work, but then there's also always exceptions for like nonprofit groups, religious services, charity fundraisers, that kind of thing. So, and then finally, the right to display, that, prevents others from publicly displaying the copyrighted work. Then when we talk about infringement, when somebody engages in activities that are reserved for the owner of the copyright. And so, there for the infringement suit, you got to prove there's a valid copyright before you can bring suit, and then you got to prove it. So you have direct or circumstantial evidence. And so, what is evidence? So you have to show that the infringer had the access to the protected work and that the accused work is substantially similar to the protected work. And so when you look at sometimes parodies on something, it's not an infringement, even though it may be close to the original. Where you look at the skits on Saturday Night Live or something along those lines, is that they're not going to be subject to an infringement suit. And then we talk about defenses to infringement, fair use, independent creation, educational purposes, house of worship, free or charitable events, that kind of thing. And then they talk about, copies for personal use, that kind of thing. So it's kind of a gray area. Then we get finally into patents, where now we're talking really about inventions and things like that. And so, we always talk about monopolies are bad to the free market economy. But, and we talk about, drug companies, how much they're making off of some of these drugs. Well, what a patent is it's really a limited monopoly. If somebody spent $10 million developing a design, it's not unreasonable that they should have the exclusive rights to that design for a certain period of time before anybody could use it. So, we talk about the limitations on patentable subject matter, and then, it talks not abstract ideas, but processes, products, designs that meet other criteria for patentability. And then we talk about, if you get a patent, you can use it, you can assign it or license it to a manufacturer. And again, that patent can be valuable collateral when you look at, bank loans or you're selling your business. There's a value, inherent value to that patent as well. So we talk about the basic design patents, and really most of them are what they call a utility patent. And so it covers processes and product designs and expires 20 years from the date of the patent application. And a lot of times it can take a couple of years before the patent goes through because they look at a lot of different variables in something. Then we have design patents. So they're kind of like more ornamental, it's non-functional, and those expire 14 years from the date that the patent's granted. So, there is a limited life on that. And if, the owner of the patent can't meet the market demand, then they can license the manufacturers or service to other providers and do it that way. So we talk about meeting that utility requirement. So the invention has to be capable of either a practical application or a commercial benefit. It has to be operable, and again, it can be reduced to practice. It can't just be some abstract concept type of thing. All right, so that's intellectual property. And again, for most businesses, we'd be looking at preliminary, primarily trade secrets, confidential information, and the use of non-disclosure agreements and internal controls for controlling the distribution within the organization type of thing. So then I have related websites here. So you see I've got the Department of State, the Office of the Professions. If you go to the Trademark Electronic Search System, it'll allow you to do a basic word search. So if you're thinking about a name for your business, one of the things that I always do is I Google the name. I go into test the Trademark Electronic Search System. I'll look at New York State Department of State to see if there's similar names, and also go to the county clerk's office just to see if there's any DBAs filed under a name or something that's very close to it. Then we have the New York State Department of Taxation and Finance, very comprehensive site. You can go in there and just at the base site, you can look at things, okay, employment tax, sales tax. And then as you drive down, it'll actually, these are things that are subject to sales tax. These are exempt from sales tax. And there's all kinds of hyperlinks where you can actually look at the publications and bulletins and schedules within the publications just by clicking on the hyperlinks. Internal Revenue Service, that's where you would get your EIN and a lot of your IRS forms and instructions. And if you're getting yourself an employer identification number, if you Google EIN, what's going to come up is these people that provide services. So they might be charging anywhere from, $75 to $350, and they'll say, I'll get you an EIN in 10 minutes. Well, if you go to the IRS website, you can apply online and you can get an EIN number within 10 minutes for free. So you have to be very careful when you're going after this stuff, that you're going to the actual agency site and not a for-profit site that has a very similar, that the the one selling the services is probably irs.com versus irs.gov. So you just have to watch for that. Erie County Clerk's Office, you can go online and they have a Windows-based system where you can do an actual generic research of the online records. If you're not a registered user, it won't let you print the records out, but it'll show you the filings, the date of the filings, who did the filings, that kind of thing. And then I just have the Erie County Health Department permits and applications, the link there, that a lot of times if somebody, around here, we seem to want to open a lot of restaurants, food service, trucks, that kind of thing, that, it kind of gets you the starting point on that. And again, if you're working with SCORE or the SPDC, the Women's Business Center, Beverly Gray, all these organizations, their business advisors will have links to a lot of these kind of things as well. And then finally, just my contact information here at Roach, Lennon Brown. I've been here since August. I'm their of counsel. So that's what they give the old retired guys. They call them of counsel, and I give them an office to work.
Well, thank you, John, for the presentation. We do have one existing question that's on the chat. Does an LLC imply any copyright or trademark protection in itself? Is there a defining milestone when you need the formal protections to protect a brand?
No, LLC, all that is that shows that you've registered as a limited liability company. So that gives you that corporate veil of protection, but it doesn't give you anything with respect to intellectual property. So I guess what my response would be is, how critical is a logo or a name to your business? And I think it's become more crucial in recent years because now so many, even tabletop home-based businesses do global sales because they're on the World Wide Web. And so it's important that, years ago, if you have a corner restaurant, every town probably has a Main Street cafe in it. And so you don't necessarily need to copyright that name because, you're not selling over the internet. People are just coming in, they're eating whatever you offer, that kind of thing. So, now you look at, say, like the Anchor Bar, which now has locations all over the country. They're doing a lot of online sales. So they have probably trademarked some of their logos and their name and things like that. So if it's going to be critical to your brand, it's probably worthwhile looking and filing a trademark, because the last thing you want to do is invest all this time and effort and find out that somebody already has that trademark, number one, or somebody files it after you. And I'll just give you an example. I had a client come to one of my clinics probably 3 or 4 years ago that she owns a sewing center. And so they sell sewing machines, they sell sewing supplies, they have classes, that kind of thing. She's been in business for probably 25 years and has 2 locations regionally. It turns out that there's another, and it's like her first name Sewing Center, and that's the name of the business. And she's got, like the domain names and stuff like that, website, all that kind of thing. Up until like 10 years ago, all your sales were going to be in person or maybe local mail order, advertising through the phone book or the newspaper or something like that. But now with global marketplace, you can be selling supplies all over the country internationally. Well, there was another sewing center that I think was based in several states over that had the same name. They had locations in a couple of states, nothing in New York. And the owner remembers that, probably 15 years ago, one time she got a delivery that was for the other organization. Well, she didn't think anything of it, so she paid the postage and forwarded it to them, and that was that. Well, about 4 years ago, and they were in business probably 15 years. So, I mean, it was after she started, but in business for quite a while. Well, about 3 years ago, she got a cease and desist letter. So what happened was that they had trademarked the name. And now, because obviously now you're doing a lot of online sales, and they want the exclusive use of it, which they're entitled to enforce. And so she had to change the name of her business, and the trademark is going to supersede. It doesn't matter, what social media accounts you have or domain names or anything like that. The trademark's going to trump all of that. So if the name is something that's going to be critical to your brand, at some point early in the process, you may want to consider trademarking the name. And, one of the first starting points would be, Google it, look at tests, and I've got the link there. That'll give you an idea of if somebody else is using it. And one of the things when you look at the trademarks is trademarks are to a specific market sector. So you could have, a name that's trademarked, and somebody could be making bourbon, and somebody else could be selling jewelry, and somebody else could be making shoes, kind of thing. So, I mean, it's very narrow. If you wanted to, capture that name for everything, you'd be filing a whole litany of trademarks. So you want to look at, what would your core markets be, because it's possible that you may want to file the trademark in a couple of different market sectors.
Yeah, John, we're about a half hour, a little over a half hour after our set time limit for this webinar. So
Okay.
I'm going to ask anybody that has additional questions if they can go ahead and contact you at the contact information, which is on this slide.
Sure. They can just send me an email.
I'll also, go ahead.
They can send me an email.
Yeah, send you an email. Okay.
Yep.
I want to remind everyone here on this webinar that you will be receiving a link to the recording of this session, as well as a PDF copy of the slides. So there will be information that you'll be able to have on hand going directly to you about this presentation. John, I'm going to close out the presentation right now and the workshop, the webinar, and thank you for a very detailed and in-depth review of small business legal issues, and also to thank our attendees for joining us tonight. And we look forward to having you at future workshops, webinars being presented by SCORE. I'd like to thank John again, and good night to everyone. Stay healthy.
And happy holidays.
And happy holidays.